appellate division. Why should I undo what they decided?
Sure. So the basic facts here are not in dispute. This is a narrow legal issue of statute of limitations. So Mr. Hollis was involved in a motor vehicle accident on April 1st, 2023. He had an accident in Fulton County. And from that, the claim was accepted in Tennessee by his employer, Averitt. Averitt is their principal place of business is in Tennessee. They hire all of their employees out of Tennessee. So generally speaking, they do accept their claims in Tennessee first. I've had many claims. I've represented them for several years. There are many claims where a claimant will pursue benefits in Tennessee, and then they get to a certain point, and then they come here to Georgia to pursue other benefits. A perfect example, and actually what happened here, is Tennessee, we refer to it as an MMI state, maximum medical improvement. Once a claimant hits maximum medical improvement in Tennessee, their law allows for suspension of indemnity benefits, of those weekly TTD benefits. Here in Georgia, that's not the case. MMI doesn't hold that weight. We have to go deal with a separate causation standard. So we see often in these cases that a claimant will pursue the claim in Tennessee sort of until they hit maximum medical improvement. Their indemnity benefits then get suspended, and then they transfer jurisdiction over here to Georgia and they pursue additional benefits. And again, that's what happened here. The problem here, however, is we have a date of accident, April 1st, 2023, but a WC-14 request for hearing was not filed until May 6th, 2025. That also happened to be about 2 weeks after he settled part of his claim in Tennessee. And by that point, he had received roughly $400,000 in benefits in Tennessee. So we come here, we have a hearing request here. Averitt controverted on the basis that OCGA 34982A applies. That statute of limitations says a claimant has to file a claim in Georgia within 1 year unless weekly benefits or remedial treatment are provided for by the employer on account of the injury. And so what I'm sure you'll hear a lot from Mr. Hollis's attorney, what you'll read from the decisions below and the cases that he cites, all of that is very focused on the plain language of those words and the meaning of those words. So Averitt, the employer, did pay him benefits, that's undisputed, did provide remedial treatment. It was all on account of the injury. But the distinction we're making is that all of those benefits were previously paid in Tennessee under Tennessee law. Nothing has ever been paid pursuant to Georgia law. There's been no WC-2 filed commencing benefits here. The claim has proceeded under Tennessee law to date. And overall, you know, it is common, it is understandable, it is certainly a fundamental pillar of statutory interpretation that words should be given their plain meaning. We don't want to twist and turn statutes so they mean something that's not so obvious. But what we would put forward is that it's also equally important to understand the context in which those words are written. And so here, it is very true that 34982A never says the phrase in Georgia. It doesn't say payment of benefits by the employer in Georgia. It doesn't say on account of the injury in Georgia. We don't even say the claim has to be filed in Georgia within a year. But we don't have to say that because what we were talking about this entire time is Georgia law. We're talking about the Georgia Workers' Compensation Act. We're talking about OCGA 3491 et sequential. That is our body of law. And if you even look to other statutes that are critical in workers' compensation, where we derive all our benefits from, examples would be 349200. That deals with medical treatment. When you can get medical treatment, what's paid for. 349, you can do 261, 262, 263. That's all your weekly benefits. That's your impairment rating, all the benefits, medical indemnity that you could get. None of that says in Georgia. We don't have to keep repeating in Georgia after every phrase because we know that's what we're talking about. And so it's important here to understand that benefits paid by the employer on the account of the injury must be done so in Georgia, pursuant to Georgia law. And I would also point, Your Honor, to Judge McMurray's dissent in one of the cases that comes up in sort of this body of law and what the appellate division has cited previously, Sprayberry versus Commercial Union Company. The dissent sort of said it best. That case was all about deciding whether the employer could take credit for benefits paid in another state. And indeed they can. Indeed, we have dual jurisdiction. Our statute contemplates that. No dispute there. But Judge McMurray then said payments made by the employer must mean payments made under the statute. And if no claim is filed, then payments otherwise made by the employer cannot be considered payments under the statute. That makes sense. And further, sort of the reason this makes the most sense, if you take this idea to the logical conclusion, the misstep that the appellate division has taken, not only in our case, but in a 2011 opinion that has come up in this case, and you'll see it referred to in our briefs, when they say they're looking so hard at the plain language and payment by the employer on the account of the injury, that they then take this next leap and say, in their opinion, that even payments made by the employer, that includes payment of benefits pursuant to workers' comp laws of any particular state. And that is a very broad, way too far thought that goes far afield. So keeping in mind in workers' comp, payment of certain benefits triggers when a claim is compensable, or also in this case, triggers when a statute of limitations applies. And so to be consistent, if you say payment of weekly benefits in Tennessee counts as the same thing as payment of weekly benefits in Georgia for the statute of limitations, you must also be saying that payment of benefits in Tennessee controls when a claim is accepted in Georgia or not. And that could be Tennessee, that could be anywhere. That could be California, that could be New York, Texas, Florida, anywhere. And the statutes are wildly different. And it's more than just administrative details here. What we're talking about is when certain benefits are owed, how much are owed, when an employer is obligated to pay these benefits. And so you quickly hit very bad consequences if you say payment of benefits in another state tolls the statute of limitations here, because now you're letting the laws of another state control not only the statute of limitations here, but compensability here, and when benefits are owed here. Moreover, you're going to hit another inconsistency, because if you allow payment of benefits, and this is this case, payment of benefits in Tennessee works to bar the statute of limitations here. That's what the claimant wants. However, he doesn't want the denial of benefits to apply to his case. We have Tennessee denying further indemnity benefits because he's hit MMI. But that's not the law in Georgia. So are we going to